Assalamualaikum and salutations. We the hustlers of TG1 and will be discussing 5 cases for assignment 2, task 1. Ignatius against Bell, 1913. Hadley versus Bazendale, 1854. Leha Jusso versus Awang Johari, 1978. Li Chinyen and Anwar versus Mbak Sun, 2014, and Lau Brothers & Co. versus China Pacific Navigation Co. Ltd. 1965 will be the cases that we will explore briefly in this article. After a brief introduction, we shall continue with the case of Ignatius versus Bell, 1913. Let's get to know each other first. Nurul Farisha binti Sazali is my full name. When Mr. Bell agreed to grant Mr. Thomas Ignatius an option to purchase land belonging to Mr. Bell at a price of 5,000 in Ignatius versus Bell, the plaintiff had to accept the offer by posting a notice to the defendant's estate or by tendering money to the defendant's residence by August 20, 1912, if the option was to be exercised at all. On August 16, 1912, the plaintiff sent a notice of acceptance to the estate of the defendant through registered mail in accordance with the provisions of the agreement. It was not until the 25th of August 1912, when the defendant went to pick up the plaintiff's letter of acceptance, that the letter was delivered to its intended recipient. Despite this, the contract had already been terminated when the plaintiff failed to pay the purchase price. After suing the defendant, the plaintiff argued that there existed a contract that the defendant should be held to it. In this situation, the question was whether or not the acceptance was legitimate. Because both parties had agreed to send acceptance notice via postal mail, and because the plaintiff had done so correctly and on time, Woodward J.C. found that the acceptance notice were properly communicated and thus construed as binding contracts, even though they did not reach the defendant in a timely manner. Under the Contracts Act 1950, Section 4 of the Contracts Enactment was used in this case. The section states that once the acceptance is in the hands of the offerer, it is no longer in the acceptor's control and cannot be changed. Because of this, the Postal Acceptance Regulation mandates a postmark as proof of acceptance. A genuine contract had been signed by both parties and the acceptance was full and unconditional when they post their notice of acceptance on August 16, 1912. But the deal was terminated when they didn't provide payment even though a contract had been signed. That's all from me.
Good days to Miss Ain and my fellow friends. My name is Syafiqah Nabila binti Rosle. Today, I am going to present about Hadley versus Baxendale 1854 case. My method of relating this case is to use references from Contract Act Law 1950, Section 74. In these cases, it's established claimants may only recover losses that reasonably arise naturally from the breach or are within the parties' contemplation when contracting. As for the fact, the claimant Hadley owned a mill featuring a broken crankshaft to the location at which it would be repaired and then subsequently transport the crankshaft to the location which it would be repaired and then subsequently transport it back. The defendant then made an error causing the crankshaft to be returned to the claimant a week later than agreed, during which time the claimant mill was out of operation. The claimant contended that defendant had displayed professional negligence and attempted to claim for the loss of profit resulting from the unexpected week-long closure. The defendant retorted that such an action was unreasonable as he had not known that the delayed return of the crankshaft would necessitate the mill closure and thus that the loss of profit failed to satisfy the test of remoteness. As for the judgment, the Court of Accountancy declined to allow Hadley to recover lost profits in this case. Baxendale was not liable for the loss. The court held that Baxendale could not be held liable for losses that were unforeseeable if Hadley had mentioned his special circumstances in advance. Baxendale could be held liable. Hadley has not mentioned that his business would remain closed due to delay in the shipment. So this case was related to the issue whether Sinchan claims his compensation against Travel Local Express even though he did not follow the instruction given by the second bus driver Takashi to put his goods inside compartment bus storage. That's all for me. Thank you.
Greeting to Miss Ain and my fellow friend. My name is Avin Dareu. My number metric is BB20403 and I will present relate to the case between Leha Juso versus Awang Johari in 1978. This case is referred to the Section 11 of the Contract Act 1950. According to the Section 11, provide that an individual may sign a contract provide he is an adult under the law to which he is exposed of sound mind and is not prevented from doing so under any rule applicable to him. So the fact of this case is that a child has entered into an agreement to purchase a piece of the land from the party administering the estate. The agreement was carried out, that is when a plaintiff was a child he made a payment of 5,000 and the plaintiff was allowed to enter the land. The High Court ruled the agreement was void because it was done by a child who was not qualified to enter into a contract. The defendant appealed to the federal court so that the agreement could not be enforced. The court ruled that the agreement had been void from the outset and in accordance with Section 66 of the Contract Act 1950 that Leha Juso had to pay 5,000 to Awang Johari when he left the land. So issue related from this case is whether Makio sue Nabisuke for not repaying his debt within 5 months. That's all from me. Thank you.
Assalamualaikum to Miss Ain Shaliana. My name is Muhammad Dzuliskandar and I would like to talk about the true case of Eng Bang Sun and Ors versus Lee Chin Yen and Anor in 2014. This involved Contract Act 1950. When a party fails to fulfill or becomes unable to uphold his promises, the contract will be cancelled. But if he has expressed his concern to its continuance in writing or through action. The first and second plaintiff, as well as the defendants, were shareholders and directors of two firms, Central Aluminium Manufacturing Private Limited and Ji Seng Hong Manufacturing Private Limited. The parties agreed to part ways after mutually unlocking each other's interests in Central Aluminium and Ji Seng Hong Manufacturing. As a result, on January 26, 1999, the parties entered into 4 agreements in which the plaintiff agreed to transfer the entirety of the interest in Central Aluminium to the defendant for an agreed upon sum of 5.97 million ringgit Malaysia. The judgment in this case are the court awarded the plaintiff 7,120,490 ringgit Malaysia in damages, plus 4% interest from date of the rate until full realization and 50,000 ringgit Malaysia in expenses. This case involved an issue which is assessment of damages in lieu of rescission, whether the court was to assess damages in lieu of rescission and not damages for breach of a collateral contract. Approach to reading court orders and written decision with a purpose.
In this issue that I looked through from the cases is Lau Brothers and Company versus China Pacific Navigation Limited Company 1965. In this case, negotiations for the delivery of logs were conducted through a series of telegrams and letters. Whilst still in negotiating stage, the defendants withdrew. Was there a binding contract between two parties? The court held that the parties were still in a state of negotiation and no agreement was formed. Therefore, the defendants were justified in withdrawing. These studies that I have used is connected to the Contract Act 1950 Section 9 and Section 7. Based on Contract Act 1950 Section 9, it explains that a proposal converted to be a promise if it is implied as from Section 7 of the Contract Act 1950, which it said that in order to convert a proposal into a promise, the acceptance must be absolute and unqualified. So according to the judgment where the case study and issue that I have done, if the parties are still negotiating, an agreement is not yet formed, according to the cases of Lau Brothers and Company versus China Pacific Navigation Limited Company, 1965. But the issue that I want to relate with the cases, which is Jaiko never deposited any money as Nobita discovered about that, so he asked Shizuka to claim the rent due from Jaiko. But Jaiko still refused to pay even though Shizuka threatened her with police report. So why did I relate Lau Brothers and Company versus China Pacific Navigation Limited Company 1965 with Jaiko versus Nobita and Shizuka is because it is already stated there that if the parties are still negotiating, an agreement is not yet formed. So through Jaiko versus Nobita and Shizuka, agreement is formed even though there is no written contract, but it is stated that as promised. To put in a nutshell, Jaiko did make a promises to pay. So Lau Brothers and Company versus China Pacific Navigation Limited Company 1965 is the cases to support my opinion that Jaiko must pay even though they did not make any written contract, but she still need to pay as promised.